All right, this is 2301458 JP Morgan Chase Bank versus Arnold Chavez appearances.
Uh, yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez, Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Welcome back to the channel, folks. Buckle up, because today we got not one but multiple courtroom showdowns featuring some of the most puzzling and honestly entertaining defenses you'll ever hear. We're diving into the cases of Arnold Chavez, who's decided to take on JP Morgan Chase and Discover Bank with arguments that sound more like late-night YouTube conspiracy theories than actual legal defenses. What makes this fascinating isn't just the drama. It's the collision between hard legal facts and sovereign citizen logic, which tends to collapse under the slightest push. Judges here are patient, but also razor-sharp when cutting through nonsense. Stick around, because one moment you'll be shaking your head, and the next you'll be laughing at how absurd some of these courtroom stunts really get. And trust me, the deeper we go, the wilder it gets.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender.
Here's where the cracks start showing. Arnold insists he hasn't received the interrogatories or documents, but the bank's attorney claims they were sent. This isn't just a petty, he said situation. Discovery is the backbone of cases like this. If you're missing evidence, your defense crumbles. But instead of focusing on proving he never got the documents, Arnold is setting up a sovereign-style pivot, trying to steer the discussion away from the debt itself and into abstract arguments about accounting and banking principles. It's a tactic: distract, delay, and deny. The problem? Judges don't grade on creativity.
My personal security, which I'm
No,
entitled to rights to.
no, I'm not buying that. No. Listen
Okay.
to me. Listen.
It's not about. I have it. This. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You
Is
took
that-
a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating.
I will get that out
motion for
right
summary
away.
disposition.
I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th at 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all.
This right here is the smoking gun moment. Arnold admits he had the card and used it. Game over in most civil debt cases. The judge immediately zeroes in. Did you take out the card? Did you use it? And did you fail to pay it? That's the whole ballgame. Notice how Chavez tries to twist things, claiming he's actually the lender and the bank somehow owes him. This isn't just weak, it's completely detached from contract law. Once you swipe that card, the liability is yours, not the bank's. I am the lender. Defense is classic sovereign citizen theater, and the judge isn't having any of it.
And I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
The sovereign citizen accounting smokescreen. Arnold argues that because his application opened the account, it somehow created money or a credit in his favor. This is a recycled trope straight from internet message boards. The idea is that banks secretly use your signature as collateral and then double dip on repayment. Sounds mysterious, right? But in reality, the application is just consent to borrow money under agreed terms. The only thing it creates is debt. The judge knows this, the lawyer knows this, and now the audience knows this. The only person who doesn't? Arnold himself.
All right, here's what we're going to do. I'm setting a date. So what, do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to.
And here we go again. Arnold isn't just fighting Chase. Now he's taking on Discover with nearly identical arguments. It's deja vu, but with a new plaintiff. This time, his excuse for missing a prior hearing? Xfinity internet problems. Believe it or not, the court actually accepts this as a valid excuse because technical issues in Zoom hearings are treated seriously. But here's the catch. Even if the excuse works, Arnold still needs a legitimate defense. And as we've already seen, the bank owes me doesn't exactly pass legal muster.
Summary disposition is granted sua sponte by this court. There is no valid defense to this claim. And
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. We're all set. Thank you, Mr.
Arnold.
Mr. Arnold, I have ruled against you.
I have
am allowed
evidence.
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your
This is where reality hits hard. The judge carefully explains what due process actually means, notice and a chance to be heard. Arnold had both. The problem isn't the process, it's his defense, or lack thereof. By admitting he had the card and used it, but failing to provide a credible reason why he doesn't owe the debt, he left the court with no choice but to rule against him. His affidavit, no matter how passionately written, can't erase his own admissions. Due process isn't about endless retries. It's about fairness. And fairness here means you borrowed, you pay.
Mr. Moore, you can come forward, sir. Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes,
Okay.
I am, yes, here for that matter to handle the matter that's at hand.
Okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a beneficiary executive for the said name.
Okay, let me, before I respond, let me see if the city takes any position. Mr. Gunderson, is the city taking any position on the representation of Mr. Moore in this matter? I don't even know if you're appearing on behalf of the city in this matter.
Good morning, Your Honor. Will Gunderson, prosecuting for the city. Your Honor, the city does typically appear for the contested hearings in which officers have been subpoenaed.
Was an officer subpoenaed in this matter?
Yes. Your Honor, the officer is present. Officer Berglund is here. Your Honor, my position at this point is to request a short continuance in this case. The basis being I rely on the Judicial Information System, or JABS, review that information relevant to the particular case. Within the last 20 minutes, JABS database has gone down. Oh.
And
Do that now.
do you take a position on the representative of Mr. Moore appearing in his stead this morning for purposes of the hearing?
Your Honor, ultimately, the city would defer to the court on whether or not the individual is present is allowed to act on behalf of the defendant. To cut to the chase, Your Honor, this sounds like it might be a sovereign citizen type of situation. I don't know if the individual that is seated here is in fact the defendant, or if he is a completely separate person, separate and apart from the defendant that was pulled over at the time this incident took place. So that is a red flag, so to speak, or a question mark that does get raised in the city's mind, for which the city does believe that a further inquiry by the court may be appropriate. But ultimately, Your Honor, with regards to any representation, city will defer to the court.
All right. Thank you, Mr. Gunderson. So, sir, I'm going to ask you to identify yourself for the record, please.
I am one of the people.
I'm sorry?
One of the people.
Okay. Are you or have you been previously named or identified by the state of Washington as Sherman Moore?
I am not Sherman Moore,
Okay.
the entity in which you speak of.
Okay. And do you have any relationship to Sherman Moore?
I am just the beneficiary of